Residential listing contract, exclusive right to sell or rent. This form means you're hiring me to list your house. Section 2 is about the property. Section 3 are the listing price and terms. How you're listing the home. Are you listing it to sell, rent, or both? You can do both if you want. Owner acknowledges. This can expose the owner to liability for commissions. Price. The listing price is what do you want to list it for? We're going to have quite a discussion about it, but this will be filled in together and mutually agreed upon. The term of this transaction, there's always a start and an end date. If you're going to designate someone else to do your paperwork, this is stating that you have that legal capacity, and so do they. Modifications are only in writing, not verbally. And equal housing opportunity, I take that very seriously. We must treat everyone fairly. Compensation. You have a right to negotiate what you pay me, and you have a right to negotiate what you pay the other side, the other agent's side. Retainer, line 34. If there's a dollar amount there, it means within 5 days, you're going to give me a retainer, and that retains my services, my commitment to you. Compensation. I want to make sure we pay a little extra attention here because it's broken out kind of a little weird. So the total commission is on line 39. That's going to be the sale or the rent price. It's either a percentage or a flat amount. There's an additional broker commission if the house is for sale, which is $225 at present. That's a Coldwell Banker fee. I've probably already explained that. If not, I will soon. Cooperating brokers. That means either the rental agent or the buyer's agent. They are going to be paid a percentage or a flat amount. If the property is for sale, title takes the proceeds from the sale and pays the commission to both the listing agent and the buyer's agent. If this is a rental, the owner has to write a check and send it to Coldwell Banker. This we're going to kind of skim through a little bit. If there is a rental renewal or extension, if it's applicable, there'll be an amount there. If the tenant purchases it, I typically have it within 60 days. If a tenant is there for a year and then decides to purchase the home, if there's any amount written in for the sale, then that will be what you pay me for at the close of the escrow. If there's a dispute between the two realtors, we actually have a process and a system for how do we communicate with each other. If there's going to be a withdrawal or cancellation of the listing, then the retainer and potentially the commission needs to be paid. It depends on where we are in this process. If you need to cancel, I will discuss it with you. If there's going to be any cost associated, we will absolutely discuss it at that point. Payment from escrow or rent, I kind of already touched on that a little bit, paid via title. After the expiration date, if the listing expires and someone who saw the property while I had the listing, I will still get paid. Up to, in this situation, it says 60 days. Failure to complete. If the owner has the ability to rent or to sell the home and then chooses not to, then I can get paid. This agreement is construed as a limiting applicable provisions of law, which basically means that if this doesn't meet the Arizona law, this is the one that's changed. Fixtures and personal property. What I'm going to tell you is not the complete list. I will give you some examples. In the kitchen, if you have a dishwasher, a sink, a microwave, a stove, those are all considered attached. You cannot take them unless it's agreed to very specifically. But a refrigerator, washer, and dryer is negotiable. Anything that's attached, for example, chandeliers, curtains, blinds, those all need to stay. Pay extra special attention here, and when in doubt, ask. I am happy to answer the question for you. If anything is leased or not owned, I must find out about that immediately. For example, solar systems, alarm systems, those types of things, because that can have an impact on how we communicate that with a buyer and which buyers might be able to buy the property. Agency, we actually already talked about that, so this is going to kind of repeat just a tiny little bit. I have a duty of loyalty, obedience, disclosure, confidentiality, and accountings and dealings with you. Conduct of brokers. I must treat the other side with respect and fairly. I also have an obligation to disclose in writing all material facts that could affect the sale of the home. If I know something that you haven't disclosed, for example, you've got roof leaks or something like that, if something were to happen and you were not going to be able to close on the sale of the house, I am obligated to tell the other side. I am also obligated to the Code of Ethics as defined by the National Association of Realtors. Limited representation, if I represent both sides, or if I represent you and another Coldwell Banker representative represents the buyer, that is still deemed both of them equally in the eyes of the law as being a potential conflict of interest. What broker cannot disclose under clients under limited representation? This means if I represent both sides, what can I not say? Long story short, I cannot negotiate for either side. I can only tell the other side what the other one said. I cannot make suggestions or encouragements or anything along that line. I can't pick favorites. Competing owners. This basically says I have the ability to go find another seller in your area that might have the same floor plan, and I can list their home as well. Broker authority. Broker's role. I am not responsible to do any repairs or fix up the home or anything along that line. In fact, I am specifically not allowed to through my broker. Advertising. You agree to not advertise the premises in any way outside of what I'm doing without my written consent. Some of those advertising options are multiple listing service. We absolutely need to do that. All terms of the transaction, such as sales price, financing, etc., will be provided to MLS. Signs, that means a yard sign. Do you want one in your front yard or not? Photos. I highly recommend that we do professional photos. All images from the professional photographer I can use for any form of marketing. You acknowledge that I don't have any control over who can see the images of your home once it's posted on the internet. Lockbox. It's the Arizona Association of Realtors lockbox. It's not like what you would buy at Home Depot or Lowe's or anything like that. Offers. For the offers, we can do this one of two ways. I have my preference. If we've got two offers that are bidding against each other, my suggestion is you allow me to tell the details to the other side and say, if you want to beat it, go higher. If you don't want me to disclose any of that, you can say no, and this is going to be more like poker, where I don't give any hints away and I just say, give us your highest and best. Subsequent offers. I'm automatically, it's already checked off. Do you accept backup offers? Even if you tell me not to, I'm still going to hold on to any other offers. If someone wants to say, hold it as a backup, I'm going to. I must adhere to the MLS rules. Before we go active in MLS, I'm going to send you the rough draft. I need you to go over it in as much detail as you can. Of course, if there's any changes that need to be made, you just tell me and I'll make them subsequently. Cancellation must be unilateral. I actually do not have the ability to accept a cancellation myself. It must go to my broker. Owner obligation. Premises access. You need to try to let people in a reasonable amount of time. Security, insurance, showings, audio, video. You can record anything in the house that you want with audio or video. Definitely keep your insurance. Safeguard your valuables. People are going to be in and out of your house. Do not leave medicine in medicine cabinets. Do not leave any weapons out where people can see them. You know, if you've got jewelry, make sure you hide it somewhere. Anything that can fit in their pocket, it's your responsibility to hide it before somebody sees your home. You understand that I do not have insurance to protect your assets, so therefore you should obtain your own. If you do have any existing security devices, it is encouraged that you post a notice saying, you're being recorded. Adverse information. Oh boy. You have to disclose a wide variety of information and you must take this seriously. You're going to disclose all material defects, any possible information that you have on the house, anything that might be material to the buyer, such as if it's on septic or sewer, if there's any tax judgments or liens. If you find out anything during escrow that could impact the buyer's decision to purchase the home, you absolutely have to disclose that. If the property is unincorporated, you have to do an affidavit of disclosure. If the property was built prior to 1978, the lead-based paint disclosure must be filled out. If it's on septic, there's another form. If the seller is not a United States citizen, you must tell me. If it's in an HOA, there's a form you have to fill out. Insurance claims history. If you have homeowner's insurance, you must request the last 5 years. If you've owned it less than 5 years, for the amount of time you owned it. Residential lease agreement. If it's a lease, we use a lease agreement. Seller property disclosures. That is sections number 8 and 9. It's a similar form, whether you have your home for sale or whether it's being rented. It still must be filled out, and I encourage it before it goes active, because these are both forms that I put up in MLS so realtors can download it, share it with their clients, so we know that they're willing to accept the home with those conditions prior to them even writing an offer. You must disclose as much information on as you can. There's a separate form for that. There could be a time when you're going to ask me for different vendor suggestions. For example, a builder, contractor, title, escrow, anything along that line. I can give you some names, but it's your obligation to do all the research to make sure that that company is everything you're looking for. There are some potential vendors out there that I could receive a compensation for, although that's not typically how it works. You agree that you will not allow any mechanic liens to be put on the house. That does include post-sale. Indemnification. I'm held harmless regarding repairs, loss of personal property, etc. Section 9. Alternative dispute resolution. If we have issues, we try to not take it to court. Attorney's fees and costs, expect to pay your own unless you get awarded it. Additional terms and conditions. I always have activation of property in MLS will be at the seller's discretion, because legally, as soon as you sign this, I'm supposed to be putting it in MLS. If there's anything else written under this terms and conditions, I will discuss it with you. Assignment. You cannot assign this to someone else. Arizona law, we have to follow Arizona law. Notice. We can communicate via email, text, and phone calls. But if there's something that needs to be written down, I will always be sending it as an email. If it's a really quick description, I'll send it in text. And if I think it could be complicated and we need some back and forth communication, I will call. If we've agreed to some other system, then forget what I just said. Days, it's always calendar unless otherwise marked. Copies and counterparts. You don't all have to sign the same paper. The entire agreement. If a section, a paragraph is determined to be not valid, the rest of it is valid. And then acceptance by signing the section number 11 of the owner, and I sign under the section 12 broker, then we've agreed to work together. If you have any questions, because you probably do, make sure to ask me, and I'll try to come up with things that you might be thinking of and make sure to address them with you. So when in doubt, ask. Thanks for watching.